The Davis case is an example of in which the prosecution tried to get really clever and bring in the fact that the defendant, who was charged with the possession of a very large quantity of cocaine, was we could learn something about his possession of that cocaine on this occasion by looking at his prior possession of cocaine. Well, in the current case, the defendant is accused of possession of the cocaine with intent to distribute. In the prior conviction, the defendant was convicted of possession of cocaine only with the intent to use. There was no indication that he intended to distribute the cocaine. So the question then is, can we use the fact that someone previously possessed cocaine on one occasion for any purpose to show something that's useful for the criminal prosecution of him for possessing cocaine on the second occasion? The prosecution offered two theories. One, it said that the fact that he had seen cocaine before meant that he knew what it was in his car, that he didn't think, for instance, that his wife had gone by the market or gone by the farmer's market and gotten some loose sugar, that he knew what this was. And the court dispenses with that because they said that there would be real differences in cocaine that was in the amount that one would use personally and in the amount that one would use to distribute. Not that the cocaine would be different, but that you would package the different quantities of cocaine in very different ways. It might be in a brick if it were a couple pounds, and it might be in a Ziploc bag if it were half an ounce or something. So the amount of cocaine would change the packaging, and the packaging would give a whole different sense of what was in this guy's car. The other offer that the prosecution made was that the fact that previously a person possessed drugs with the intent to use them said something about the fact that the person would intend to distribute them on this occasion. And the Third Circuit just dismissed that as they should have. This is a whole different mens rea, or a whole different intent. The one is the intent to use, and the other is in the intent to sell. And the fact that he did not sell on the previous occasion, the court said does nothing to show that he was planning to sell on this occasion. So this is an example of sort of how creative lawyers have tried to get with 404B. And this case really could have only come up because there has been extraordinary willingness on the part of courts to introduce or allow the introduction of evidence under 404B to show not character evidence, because they don't call it that, but for all meaningful purposes, use the past to tell us something about the present in ways that look a whole heck of a lot like character evidence. This was just one of those rare cases in which the court said this is too far. The inference you're trying to draw here just doesn't really make sense. You should feel some echoes, some strains of relevance in here. What does the possession of cocaine have to do with the distribution of cocaine? And what does the possession of a small amount of cocaine tell us about your knowledge that you're possessing a large amount of cocaine? The court further said we don't even know if the prior conviction was for powder or for crack, and those two types of cocaine would look very different.